And come on, you did basically about Chairman Wontumi conviction. Na yesu ya de kakra. Na yes ase no. As a mranimni me sure say ebra say ni no chase a copy me say na no judgment ne by na we follow. Ma me misa say send ya send ni koye na nkasa no. Uhu ni say copy me say judgment ne by na otwe.
Yo me da say me the kind men share etie fo nyina ni titru NPP4 wo Eastern region me share bibia ne executive say wo Eastern region from chairman ekosi obibia so menu amene by KB Bright so me share no pa ye na menu dia me di kan akane say chairman Wontumi asemi betimi ato bia patriotic because obia he's known for mining. He's known for that. And you know, Sanyama way by no crany a hamepaye. And stress yen Ghana situation a woman say environmental degradation, illegal mining ha on my environment say. So Osha Yura Akufuado buy but modern sure say odemra bebre go akwa mu se betimi etu ase NDC aba Yura Mahama ono so no ye ne de ene de keke kan internet sure say Ghana yinina ya dwene ko bankrum se e wo se tu sade no efiri ho nanso no ade ba ko ha me pa ye ni say in your attempt say ubetu sade no efiri ho no memfa politics in room unya the politics we mupe na wa ma fight no ayedene no okuna ayedene hadinti na mekanisa unum say MPP4 aka say Chairman Wontumi chia ya chene kra na political prosecution to mean that he's a political prisoner. The reason is that over judgment here ye ma me ede to ho e ma ya nyema bebre kire say no kre ya follow procedure na nyema bebre so ankone kwan so and for me Chairman Wontumi is a victim of circumstances. Victim of circumstances ni say ye ha me pa kese ni say wona ekwa asase so krampo ye bebam kese wona ekwa asase no so mpo koye adwumadie no krampo no ene omote omufie na obi a ye say enye direct evidence mpo na emom ye use a certain circumstantial evidence e dia hwese onu mum na e kire se omonko asase so onu mum eko 20 years. For me there's a problem with that. And you know, me who say Chairman Wontumi wa shiasem na no kreni mete ye no anase nyina ete na mjidi say obia no eha obia. And you know bra we say na mo mention asem free say unim say Ghana yen criminal jurisprudence emra ye de hwehwe so bi edi boni eti o man na ye hwese be punish safo no ya dia edene paye the entire edene say it is the Republic versus Oniakono into your mining nyina including bra wa utedwem me ka ho KB Bright ka ho Mrs. Taso ka ho we form the Republic into nyina ya ho odene ne etumi ne de ko atia Oniakono be wa church say into share say Republic ni nipa ba ko pe ekun e kire say e wo se ubomodia hu se nipa no ahoodene ne Republic no enyepe enti na mrane say because say Republic ahoodene so sen nipa nti no bomodia ne ma no kwan na ontimi enye defense pa ye enti don't rush through the process at any stage bia no se kwan bi wo ho no o raise objection bia tie no because the Republic is fighting one person. Republic ahoodene so as one person enti no Oshemwa October 2025 ABC na ya the judgment by 9 months or so it me rush this serious environmental offense it me the judgment about to the extent say lawyer no ginemu say at the point kra no hu de onye because he feels say why a lawyer for so many years going to the Supreme Court to call a case in this any money na so at a point who say the Republic is rushing for something Emma so raise issues be crowd court Republic state in India through the judiciary judge or table mpatriotia say ntino Emma no you so frustrated and we a lawyer ni na o defend your client na judge or tie dwemu anase bibia wo di asem no eye wo sa no kronyame anim yapa ye esa no I so frustrated because omo na 2 minute term republic na 2 minute term enti no okase simple mra wontumi kura kase wontumi ma court anase o yare ni so ni kura obekọ no na applications bi wo ha ye de aye adwuma kura wo mu ni ho. So clearly it should say na republic ne pentem enya bibi and no pentem so enya de omope 20 years. And you know, for me enya Wontumi nko but it can happen say dem di kan ebetimi ato bibia enya environmental distraction nko any other offense a criminal jurisprudence say if the republic is really wanting to prosecute you at all costs, and in this case it is not even prosecution, a persecution at all costs, because see a ma kwan emma Wontumi emfa wo defense papa emma how pay. Now I didn't make us a republic any Ghana ni bi ye so to mano the needed time not me. Well, I have an issue with this judgment, and ye bekom kakri. The issue has to do with fair trial. I didn't make us bra say Wontumi and there's no doubt about that. Say judgment not clearly shows say Wontumi has an exclusive right. In fact, not even Wontumi Akonta mining exclusive right over that concession na ye kan ho asen samre boy. Meaning say wako akoye ne niema pepepe enya ne right. The mining lease so it mean mine that concession. So it even goes back to what Nana Akufo-Addo can say. Akonta mining is not doing illegal mining because now they have the lease. Amafo dinatem, but he knows what he was talking about. No more lease also Wontumi mining, and they were not doing illegal mining. But say obi say or no by Chairman Wontumi ho Bernard Antwi-Boasiako ho. Ebe ka chairman say me pese me come mine wo concession no. A businessman. Now be ka chairman say me pese me come mine wo concession. No one kasika ono kura wa ma site ho che se on follow hwe a ono kura san age tu mu se ampacha ma Wontumi ama ho se me de me concession amount now even to get a mining lease kura na adeketwa na me concession wo ho se me the amount mensi hoda waja tu mu court pe ye toto wa no na o se oni akon na okwa asase no so eye Henry Okum ene Michael Asibi omukwa asase so and some 28 others. Yeti wo munyina the republic say sanko from the yinya 28 others no omo na ye direct yinya now two no Henry Okum and Michael Asibi omo de republic say ye prosecute na mum ye de omo mum ebe prosecute Chairman Wontumi. Fair trial article 19. It means the republic no pentema ye papa ni bibi, because clearly if obia or no mokoto no asase so na mo che no na court no cry judgment say we didn't get any direct evidence say Wontumi was there doing galamsey whatever mining. Now until use circumstantial evidence or sen komobi koso or so could in any money to excavate bi into nunti no and Wontumi man kwan na obi a wa makwan ene obi ote so yes ade no wan pa na ka edi bone etino. So for me say opese oye prosecution na ye properly so called no man obi aka say ye tu galamsey asese le kan say ye Akufo-Addo ba ye nhihye bebre galam stop ne say ne mani nyina no pese odi tu galamsey ase now pese oya those involved directly in the so called mining or send to me a prosecutor, and those people are almost more territory so no what deal with them. But if you use those on the site of Moye Juma omo testament and also omo evidence on the ma court and they want me the ebebra na ebebra in law, if what you say on oath ukojina dekam asema abeka na mesumi kojina dekam asema mesumeka achrewo say your word against my word on oath. So it is the duty of the republic I was say or back prosecute me no say Republican no and also to me the evidence ba.
Right.
It's for me I think say there was an issue of fair trial which lawyers for now know say omugusu a omo hwenimum and in appropriate time no you bet me who dia akosi wo.
Right. Now council what can I pay and if you bring judgment in by wiki mu or party NPP akase Chairman Wontumi trial in judgment abano as a result of political persecution. My Mr. say which element of judgment are abe and said they are saying in the coy and pointed to sa point here Murezi. Of course what will be so. And you also spoke about this issue of circumstantial evidence. And you when the first time your trial will be the judgment about based on a circumstantial evidence. Why has it become problematic in this Wontumi case?
Right. Minia. Yakase Wontumi is a political prisoner because the criminal prosecution in a political persecution. They did not prosecute. In fact, we have code of prosecution a prosecutors now they need to prosecute, not persecute. And this one is persecution. Almost tatan, person yen BB. Freedom 9 months. 89.3 FM. Even at the pointer, bruh. On say Wontumi lawyer a free case in him. And the reason why I know free case in him say, or say at a point, or should the judge know. Na who so what we lawyer near or judge and the BBA said or the judge is not ready to listen to Omo. Tina say why so frustrated? Ufrimu. Now per the laws of Ghana, specifically your constitution say criminal trial biano was say only akwa asem no abono no onya access to a lawyer. So by virtue of that in it lawyer attaching a bermo. Natural justice. Lawyer attaching a bermudia manekwan non-share procedure num process the course of proceedings in no so all issues will be raised and send judgment about. Now when lawyer attaching it to me quite sad within a short period. Obaka show the catch court say me hunie maybe. Then me jidi say or see to me stay judgments. Niyanko Supreme Court. Niyama Supreme Court ma enchichemu. No ma enchichemu we are ye beba back normal judgment. What was the issue? Senior offered the count offense number 2 on the above almost say on the purposely facilitating but as a unlicensed mining activities as per section 99 2B of Act 703 as amended. Now lawyer Tachi said because that section has been amended by section 3 of Act 995, that is the new amendment number banner. That new amendment now banner, there's no penalty to that the same provision. Offense be organ be a penalty because over article 1911 more or say offense be or na penalty in say offense no untimi fa mobia. But what I say article 1911. Every offense it should be properly defined and there should be a penalty attached. But the first offense there was no penalty attached. So it means say or how kakrebi wo yen provision mu. Now or no there or say na dream no how ho. What I said there's ambiguity and never be any straight manner. It's never be any straight manner there. Any court nyabotre. Ni enko Supreme Court because constitution is say if bibi biara chire madwene so in terms of interpretation wo judge out here dwemu memfo wadwene enkase se netie nemum bomode afa ko Supreme Court ne state proceedings so it means our judgment will be stay could see the Supreme Court beka nebra papa omanyo this very critical idea with me said the republic is fighting one person. It how many days, how many weeks, how many months? And me I can say on yet because provision here clear. Now even if there's no penalty attached, or stating a whole lot of cases, the Zanoto cases, ex parte kwache jachi question case, and the kikankan, and the old case of Mekankan. That is the popular case I would do law school there, Mekankan. But then forgetting say there is a new case ex parte Akosa. Case number principle or say a crime bench no be bet me Supreme Court. Freedom. A crime back on say if there's a provision, not provision, no a year you know doing tanta says, hey, say ne bit me a year. Kofi said there be to say. Kofi say that it means that there's an element of ambiguity. And anytime we have an element of ambiguity biano, a chair say a munya clear for Supreme Court to in this matter, there was an element of ambiguity. One party is saying that Adiani clear. Yes, you can say Adiani clear because you are amended and there's no penalty. What do you have to do? You need to go to the Supreme Court because ex parte Akosa say immediate and unim say ex parte Akosa case ya make kan wase me nipa or throw away nipa a former chief justice unim de pa. Or see immediately you see those things. Say provision unclear. Provision there's a rival meaning. We candidate me say there's a problem. And now say provision a conflicted the constitution. Come to us. Na yen chiro mu de ko. Ye de beto court anim. What's a court envy? So it's political persecution. The right to fair trial. It means a open tema ye papa ni bibi. It means a oban what trial crack tell you say oh yeah dynamic kind. So if we tell you say a political persecutioner, na I will say it to me. Eka ebi onso so no bra se ye ka se bibi eye uyusu circumstantial evidence ye uyusu circumstantial evidence e will limited scope te so bia kokumobi usually tama okunu no e bia unya video evidence bia na momo hwe se akosua no dane dem certain me hu se Kwame Nana ewura dem and he was the last person ewura dem you say Kwame pie kra no odi America obi su gina babi o odi America no pie o pie mpo kra no na sekan bi kita no but ye kokota there is no evidence about say na Kwame twa akosua ti so the court will say let's use that evidence kiteni nkika mum ni ehunu say akosua epon adwuma 7 by 8 no ada Kwame nkwa na say ehunu 8 o'clock so akosua dan mo anaso akosua dan mo ade chi akosua wudi a circumstantially a bit me ahye Kwame. But here is the case. Chairman Wontumi say papa yi eba me ho papa ne ba me ho no say na me ko hu asase bi se eda samre boy baby na ho no nanka me nyaaye a anka me kwa ko ye man no so ba me ko hwehwe mu no yese wo your man bapa waji release kama to bet me ama me kwan nanka me nko man ne papa why na the concession bet me akona nim sa se ma me kwan na me nko man ne wo ko ya so oh adan ko ne ko ekọ man ne why ne be sadia no. But the point is that also Chairman Wontumi ma kwan se kone komine. Onu anya terms Chairman Wontumi. The person I know say oh so komine ne concession. No anya terms say go do nya sia. Media ye say, udie ye say, go do nya sia. Medical we ne ba befa. Ye nya ma rough sao. Enti na na say ye de ba koton wa ha. Say de mu be clear say we ko de ton ye 2 cities out there 1 media 1. Onu anya hwe. Was kone komine. On evidence which they say Chairman Wontumi ensi asase no so mpoda na obi a wa ma concession say combine na fa gold brass na so wansi hoda it means say enya gold no share say combine Chairman Wontumi so no point ne say o ka kire say o person your reclamation and also when you can go and reclaim na mum udua nkube ne say ne mana na je nyina ya jaso mfaso asase tam kese Inti enunti kra na asase mpokro nsi so. Konim say you are doing reclamation. Enunti pokra na uka so per machines no di wonim say madam for biton bi ene yanko na kotobi because the purpose of say okay reclamation. Senya political persecutioner. Adentina the word of Henry Okuma ono muma kwasa ase akodi bone. Any the words of Chairman Wontumi are conflicted by section 11 of our evidence act or say se wo a we prosecution wo momu no ana se odi obi court se wa criminal year you have the burden of proof. The burden of proof no eya wo dia it wo hear criminal jurisprudence as you obi court na yesi ebedi na asem a your prosecution nko and the shall say bone inclusa because media accused una was in my body way. So the constitution say I am innocent until you are able to prove to me say my body be. But what I say, okay. Now here is the case. You have the words of Chairman Wontumi against the words of Papano. I didn't see a court. It's me for Papano there. So the position of the law say, if you as a prosecutioner, we are Republican, or kwatia nipa bakono. If there is a word, your word, now only akono so kasa nyese netia, you the prosecution, it is your duty. So the evidence, empirical evidence, a bit me abe cancel the or no can one fashion ama court ne fa baako. The no fire or far the Henry can judge amount median. So it means clearly when you see the principles of evidence you know court or no the any say there is an intempebi yempe na yefa papa ne enko just to set the record say you cry you quite illegal whatever mining
council okasa about say abrantie Henry Okum say more kan so oni Chairman Wontumi yen hihye no enkrata asem bia ambem and Chairman Wontumi did admit in court say reclamation hunsemi oni abrantie ne nyanti asese onkoe eno so na nya dia enkrata da so enkrata bi eni ho a kire say I made ma say corner koye reclamation as against the word of Okum dia worker say there be okase me nkoye mining enti say o de o asase anase o concession mo bi say onkoye reclamation which in essence a form of mining service ya nim say brand says answer no bi betime di dwuma bi etesaro e was say unya written approval from the Minister for Lands and Natural Resources one that is clearly against them rano enti say nature mountain be na no okase make a secure reclamation man kase ko na kotu fam agudia adanse ben ne wo ho ye che se de wo kan ye no krana de Okum e kan e ye ntwo
adanse a e wo senke beda di ma nyina ye hu no e wo senke fi prosecution o the enti ameka say say Chairman Wontumi is innocent until you are able to give us evidence say see here adanse ne wo say fi Chairman Wontumi o me na wo prosecute me na wo beche me no o say one me de or the say mama obi kwan say onko assassins me concession so what I say without or the say minister's approval. Two, o say ma facilitate say onye other mining activities which includes land reclamation. What I say now say adansi bia or say komumum na edeba. But anything I make say the second charge I did bought Chairman Wontumi purposely facilitating unlicensed mining. On say no say that provision was in contravention with Article 1911 of our Constitution. It won't be crime issue because there's no penalty attached. But until even if Chairman Wontumi crime ma ho say koye reclamation no factor be anto so krana. That is why we are challenging that aspect. So that aspect come to omobo ase em ye call Supreme Court Supreme Court case ye kan ye no ade ni mu da ho mon kono m koto aso da bi ye kan no ade no emu na ho. So let's give you the court which is a lower court to the Supreme Court ye ma baby also offer anka e ho no kra ma. So we cannot conclusively say Chairman Wontumi made a mistake because NP in the Supreme Court. And now two. Now, if say Chairman Wontumi and that share judgment in ma, I didn't back me share you say no, there's a problem. And they say the court used the word permit. Permit. Chairman Wontumi permitted. Chairman Wontumi permitted. Chairman Wontumi permitted anyone. Permission is not the same as transfer. Because over a land act more. Section 64 or say a dear bit me a good title it will be a conveyance and the permission. So it is only when you have the conveyance, which is the agreement properly written or reduced into writing, now properly executed and no the title to do something. But the court was not looking at whether or not Chairman Wontumi a certain conveyance. The court was looking at the mere permission. Conveyance, any permission, or saying, because I can permit you to do something without even a letter. Bra, you will make me permit you to say your baby. But if I let it be unto but Osha charge on the board now. My main kind the first word no consider assignment of mineral rights. Bra, assignment of mineral rights per section 14(1) of Act 703 is a legal term. It's a legal term. Assignment, transfer, mortgage, those are legal terms. And you cannot just replace assignment with permission. So if say ono kwa do a wodi court no say Chairman Wontumi assigned, it means that you have some evidence that Chairman Wontumi executed an assignment deed. But what I say, conveyance. Some media ma Henry Okum. But here's the case: prosecution and me biama. When you be sama, Nidian say instead the court was rather using in the judgment in a permission because Omunim said there was no assignment by Chairman Wontumi to Henry Okum. And in the case, the judge and young one was attached as about 20 grounds. If you clearly read Ninyamana, confliction be woman to say, there was a problem. Our judgment in him. And young one, in fact, they can even get more than 20. If someone can more, they can get more than 20. Because charge at your bomb, they say, I assigned it. And Nano said, it is only assignment. And a young from so, and Nana said, it is permission. Because these two words are not the same. I can only assign. I also the bomb. Not say, oh, no, quite do both for. Oh, say, my assignment there. It means all evidence that say, my assignment. A bias, me need direct evidence. Nimum court to use circumstantial evidence. And I did prepare a control fiancé. So for me who say the issue about land reclamation, Chairman Wontumi and for conveyance beyond to so, and I said agreement beyond to so. That is why we challenged it. Senkenko Supreme Court. Because that part in the crime, there's problem with it. And then the issue about Chairman Wontumi said, make us say land reclamation man, can say mining. And also so no, yes say the prosecutor no the state no the Chairman Wontumi akojina court anim no. Ono no so the evidence e ba. See you who crata say Chairman Wontumi asensan. But one fa hwe amasa. It means that Chairman Wontumi and unim say your criminal jurisprudence in bra. The standard of proof and no the standard they say you need to prove beyond all reasonable doubt. Since some year menu wedding comosisi you could see say I say doubt in kitty be a wadian because oh shed the way kana any the way kana I didn't doubt him. Immediately the position of the law is said immediately you see said there's doubt kakra bi wo a year prosecution no evidence in no discharge the person man in court. Right. Because when me meet the standard say prove beyond all reasonable doubts. And over there so many doubts. Say you couldn't even get conveyance be a chese wa EBB. Say obi papa na ka say Chairman Wontumi say me kway mining. Chairman Wontumi say there be make us kway land reclamation. Want me and evidence be because it is your duty. So the man superior evidence to prosecute him. It is not his duty to give you evidence to prosecute himself. And you know, oh no, what take it back? And all these statements were on oath. Omutrantra, perjury. But what for back and we jab back there? When is na yen criminal jurisprudence, you know, or two actually.
One other argument a free side, make outside that from the side of the NPP about a year. This issue of a year going beyond Akonta mining. Yeah, make us say almost hold the Chairman Wontumi as an individual responsible for Nema. Yeah, make us say campaign, you know, because the attorney said mining lease at the mine, Akonta mining at the moment, yet Chairman Wontumi as an individual. So the court went beyond the year corporate bill and said, yeah, Abba Ewo discussion no emun. And now almost hold the Chairman Wontumi responsible. And I bet to just say Chairman Wontumi ban the company ni BBA ma or no one directed. This has been an argument a free or side in the eba. Yeah, they are ma corporate entity. But ye name himself corporate entity ni say be nipa ne di anymore. That's a nipa na for ma. emra ben na etiase nipa no no edi sa entity nenim ne yetwe ne ba emra no enim na yema ne ebeyi ne nseman
onim ofre yen Companies Act ni mo a and there's so many cases, Solomon versus Solomon, Moko versus Kuma, and so a whole lot of so many myriad of cases. When Solomon versus Solomon case, and the principle of that case, and they said, when I establish a company with a registry of companies, Felix Osafo-Marfo Company Limited, immediately I establish that company by registration. The company becomes a distinct body. Not a natural human being, but then an artificial human being from me and me co-established here. But then beyond Osha Echira, me na me cousin say any nipa bia me ne bra penny. Yes, since I say any directors, any shareholders. So it means the company technically yeah for me. But immediately we register ujinan baby nko and ujinan baby nko. So the position of the law is say that company, because it is an entity, because the law sees the company to be an artificial body, human being, that company can sue on its own. So Freedom FM Company Limited can sue me, but what I say through the directors. And I must make us sue Freedom Company Limited if there's a company like that. So that is the position. Now, if say company ni koye bonibia, usually the position of the law is say because it is not a natural being and human beings are behind the company, controlling the company. When company koye bonia, it is one of the means you bit me aka say ye PSV no. There's a curtains kata company no oni akuna nim. Nti be curtains no, ye curtains na ahwe de o tie chira o yes anymore. Enu bi that trend no and judge news here. I mean that is okay. That is within the law. Companies Act and all sort of acts are provided. So many cases. But we are saying say, bra, Tamamuntumi or any criminal ibia. So.
In this case, clearly Usha charges said the man no near castle yeah.
So Ushima na me dwene say say ye PSV na enye easy sao. It say Oka say okoje obi details for bank until say quarter amount. It's not easy so bet me akonya details no. I just a quarter amount order say bank provide the details as no my cause nyema bi wo ho aye piercing rough off. So piercing the veil covering the company and as a directors no, unless say only directors in your criminal activities be. But there's no even direct evidence that Chairman Wontumi was doing any criminal activities because Chairman Wontumi in Pokrano no mining lease. And near mom ko hu asase no so no e oni pakuna no so no. So directly obi ebone and the best one all in the sense say yes or permit ye. Yes o assign you or permit ye. We catch him say oh okay na koye na so betimi ayamam bi akona koye. Ne bone ani o. Ne bone ani. Se Kofi aba me nchen se me brapa ni me pese wo de wa mine ni mo chem pese me ko asase na ka me koye reclamation ni se ne man. Osenia wo de kokone koye. Chairman Wontumi bone yani. Ana mo se ne be PSV no because Akonta mining lease near Lydia. Nti Akonta mining a permitted ya. Any PSV no PSV no Chairman Wontumi ne Kwame Antwi ene share chiri. Ene e bechi mu mienu. Na omo asase no so de yent wom. Omo ni ade atumu so omo from so nti because omo ba for plea bargaining. Ya de omo de na atum. So omo de omo mra na ban ne Monica. No do metu asesi kana. Ni mu Chairman Wontumi de ya nyintumi sa.
3.3 FM.
Political persecution.
The evolution.
So what me ade oni papona no wasase no so de atumu se wo de bra betu asika ne fa ahokodi. Na oni akon o ka say oh you person ye de akoye sa de we mame. Enya de boni o. Kone kwa reclamation mame. Aye nyina ka say ye per mine say support services say reclamation. Chairman Wontumi boni enti wo PSV na akɔhwe oni paako a o share campaign na chi. No akɔhwe oni paako no kwa. Is it not politics?
Talking about permitting Henry Okum and the 28 others are all count myself. Chairman Wontumi so castle koye reclamation. I will go back to this issue of documents via and 9 share or any a year so. Now on an ankes casem so only be also being koye juma or assassin so. o metu ya say oye wi ase na meyo bibia sa ambem na branch ni say no o ka say me nkoye mining na menye reclamation mining ni de menya wo na me mfa ntua me ho eka. Is that not by way of allowing individual and say I call na koye na ko tu egudi ni bi?
That's a good question, senior. Granted, it's a very good question, and it's the one analyzation near pa. Granted, say, bra, okum eba Chairman Wontumi na Chairman ka say, ene koye reclamation na ema say them no why verbal arrangement. Now, Chairman ama okum 2 cities because, mind you, evidence suggests okum is also a small scale miner. So when you obey to say me mini machine cry ye drink one be am obi dem nti me dem me ba ho na me ka bi se chewa me pe bibi scan na dey acquire reclamation amount but mine will come a small scale miner and those miners they know themselves me person me kan wa yi to me machine me person mo ko kan wa yi gus ma na e bi kura na si me kwan bi
Free
so probably and I'm not saying for certainty those arrangements could have come because minor against minor and doing reclamation some na no ho na wo sisa eyagum na wo ya wadu akube e bia na akoba say we should do some arrangement but then arrangement about chere say okuma na wo wi adu akube na Chairman Wontumi oye farming pa nso oye brobia no kra na issue aba ho oye farming pa udu akube na so oye minor ye gina so ebetimi anya ho fa so o ma anya sika arrangement me patriotic ase that is okay. Now, so wo kumu so say Chairman Wontumi say koye mining. Na why pa na de ne concession be ma wa. Okoye mining. Na eno so pokura no ono nya sika arrangement. Una ade me akopoto. Your word against my word ni bi wa maka say if your word is against my word on oath, you have to the prosecution the state bring some serious evidence to clear off memen seminar. Now okumu say Chairman Wontumi ka kire ne say one konkoye mining ti how bra and that is why I'm saying doubt be war and anytime be who doubt be no it means say Chairman Wontumi nya boni bia per criminal jurisprudence okumu say Chairman Wontumi ka say konekoye mining fa me concession konekoye mining you say okumu say Chairman Wontumi eba asase ne so time o ka say koye mining o say there be no ka say me ko gold bia menya bia no me fa gold ni bi musika any reclamation busa ho say or say or I should use part of the proceeds to reclaim the land busa ho say another part no kaso fanya there Chairman Wontumi kompiska okum so aja tum say Chairman Wontumi kra anye one cedi kra fin ho enti bra so bia ko the concession a whole company na o se koye no aka che say part of the proceeds dan tu koye na wunya gold no wo the part no reclamation no part no ibusa so the ma Chairman Wontumi da bi doesn't no raise certain he say a chese papa na nkase koye mining ko kase koye mining na ko beba sasen so say gold na wutu no unsisi me unwia gold no bi because say miners in the gold hu here mpa no anti no mo nemo so wa ma hompo na wona akoye ye now the part in the crampo so called reclamation there was a fakoya we are anti part no Chairman Wontumi was say part no there for nyina etino clearly it shows say Chairman Wontumi ansuma papa ne say onkonkoye mining bia wasase ne so because ko bedi akire no wani akire kura na obema ne boys edi akire say omi gold na mo hwen say ehfa ne yakwa koton no ye ton no san na me papa ne check it because what is part of a proceed what is part into Chairman Wontumi onim nyansa sebe say ono se kokoyi asase mu gold wa ko pesi kada akwaje release na uwia gold abeyi bia Chairman Wontumi so ma mehwe e bi ko ho na gold no wiase gold no akosho o so ndo ma mehwe uyi gold akese ni nyina na fa ko reclamation part ko na part no sa fa wale be sa de no na me kwa menya mine akra ne say calculation we mentina say sisimi sa so if okumbe dina adaka mu ogitum say Chairman Wontumi ama ho a it means that Chairman Wontumi hu ade ne say just normal kika and yagum reclamation tino hu nya so be den obekọ ho but what I said etino o say Chairman Wontumi ogiska ni bi one city kwanye it means say enya mind no ka se koye nti no expect any proceeds say emra yes Chairman Wontumi o pesika ye ni campaign oni di wachi nyi sika kese bra we nyina kire say there's so much doubt evidence prosecution no at the back court na nyema mu nye so clear because medical can say the burden of proof what the states on mine so it's more evidence nye so clear doubt be anim and the standard is that there should be no reasonable way I will say clear here is the case a serious matter like this if we sue circumstantial a circumstantial and say I will say conclusion no I will say evidence no onyema nyina nyema okikabo nyina should lead to one irresistible evidence fact one without any doubt one but if you nyema we nyina buma and lead to that right. Because so many doubts I was saying
or party NPP aka say there's been some people in government and I say NDC amanu common release say ma allegations about say omo galamsey ya ehun be hia say investigation because so my misa say sa issues ya mu raise no e ba ya che yentin say makasa ho until Chairman Wontumi judgment ni e ba are you now raising these issues because no ya the Chairman Wontumi akotum he is one of your own you know say sadia any ateka mo dia yan was said the other side so because
brother say Yamin ene abanga omu ye national officers of the NDC abanya ti hosisi an NDC abanya e free NDC mu na aba now if Yoko any impenifo there's petition say same penifo mienu akoye niema na so mu ye illegal mining na galamsey ni se niema na on kwa the illegal mining no highly against the law the mere permission the mere permission there the 9 months at me the obi akotum 20 years obi a petition na kwa yes one do illegal mining bra akosi sen so if you raise issues no na kodu Yoko a because we don't control the machinery of the Yoko unim the Yoko ya yesisi we cannot say anything. The only thing that we can do is say the civil society organizations any penny for Ghana they are no can say motion na mon kasa asem we now they are asking from say even the president His Excellency Mahama no ankasa ba betu na numu too clear say onim say certain elements within one party NDC galamsey now we the I was 2 days when you me the president won him knowledge of a sin clear the president of the republic said I know knowledge that certain elements yes A B and C galamsey yes one with my permission on galamsey what can we do MPP kasa ya because they control the machinery including Yoko in the judiciary. Sorry to say that because now the judiciary him said they are corner. It's and then again your friend Papa Muhammad Yakubu or your MP ewa half one no south wo baby on any DC here on what says also on the 4 years in the year what can we do? The only thing you bet me I say Ghana for more show we mu nyina wo ye kan petitions are called president or petitions are called Yoko ho and no the man fee and all these petitions illegal mining and won't be the illegal name we so my certain permission keke permission no any assignment in permission and no the uncle 20 years so it means the political will a buying Yuvra Mahama buying also did fight galamsey no enye no ye no persecution hwehwanimu konkonsa ni se ne ma no ene se yanyame yenhwe etise na say social media ma ko kasa bibia ne akochene akọ we ko kan akochene we ko kan achi no na so mo chire ba ko ehye ba omi adi mu hwehwanimu bra se wo no checheche nkrofo na ne wo se mo bia ko kan bia ti ba omi ati akochene ma no ba omi abe complain bia chire so hwehwanimu niema se yenfa ba Wontumi enye the scapegoat see a fight I'm telling you go now Some say Wontumi na ye bibia. Now ko hese galamsey no binding measure so for me NDC ni political will and the MPP civil society organizations and the likes they bet me aka say e be ye ho enkomodie si ya nya bia yoku you need to me bia wo ho papa ne pa an obe prosecute on penso a set ye ni.
All right, me sure say judgment ni by we nya bra kan it's about 56 or 59 pages so akan mu bia o hwe mu no say Chairman Wontumi no lawyers akaso mo kwa appeal options ben na available to me mo no quick na ye mra o contest na o comes
but me that say options in the bebre. You see, when you are going for an appeal you raise certain errors at the trial judge, you know. Yeah. Errors a bit include say the trial judge, you know, or the initial evidence beer. No so called the initial that evidence is a cake. And I say the trial judge, you know, will apply the principles of law ni ye is an error. And I say the trial judge or tia dwumuno emre bia or the year juma no same no kran na en so the year juma. And I say the trial judge will ma fair trial. Send the money be na no obe yusu.
Ti bi wo judgment in
one medical catch say if you sue the principle of circumstantial evidence, you should go to an irresistible fact. Say the only person that will hear boneno Chairman Wontumi, and I say the fact say Chairman Wontumi hear bonne. Now also hear bonne. Get out the call say or assign ye, which is a term of art. But then in your judgment also a permittee, which is not a term of art. Contradiction. It raises doubts. You be raise after home. Because permission, any assignment which the framers of that act 703 no, and make it clear say and it is an assignment. And I to me as assignment and say deliberate when pakuna dwunu no ya tena se matter say person oye you ya tena se na makonoma sensan and no say the intentions are clear say me person me dey asase then emma. So if the framers of that act episode come use permission and come use here assignment which is a term of art, legal term, you may use as a ground, and I believe they will use it as a ground. Woman chance can be used as a ground. Two, the issue about fair trial, we need to also raise it. Say obia ono wasase no so na odi dwuma sei na say di pane de wo say won fan ho kodi oma under plea bargain na me de memra face 20 years jail. We will use it because fair trial is a fundamental human right under chapter 5 of our constitution, specifically article 19. Fair trial. Ghana me say Ghana a constitution or person boy your right to buy for one when is say if the republic has omo de Wontumi'S 8 year nipa bi no betimi I hold say into or say because of say republic na ho odine so timamufo ntino so person prosecuting na man fair trial man chance so per evidence via man the republic versus Bafo Boni or see disclose bibia man bibia person the prosecuting bia men for ba kokran to say first na buy na prosecution the evidence via te wo hon man wo yi wo court ogun so wo yemasho say twem see disclose everything but here is the case yan disclose you papa kofono e de nyema hwehwe mo no mako use circumstantial. So we can also raise an issue about say if there is a pronouncement on oath by somebody who is testifying against his former boss mo adwuma ye and then they also be testify against or no say uncle Defi say 20 years no or no na ka a now the boss will say there be a b your word on oath against my word on oath. What is the position of the law on that? The position of the law is said it is the duty of the prosecution to bring superior evidence, not the counsel only per person or prosecuting. That was not seen in the judgment. And then again, we can also use. I was reading something here. Me noti no cry. Me noti no cry. But I think I'll come to that. And then again, we can also use the issue about piercing the veil. Some of the can't catch us say the Chairman Wontumi, was he directly on the field committing any crime? No, Chairman Wontumi was not. Which is why I want to use direct evidence. Because on the one baby, on the first one, the colic minor be a dig and comobia or no yen idea. Because concession here, Nidia, tell your people because will be concessions who jam and say, oh, come on, Nibia, say the unmined portion. Hey, never concession, and the man said, Book Rayaketwa. So, Conaco minor to Mount Miamaho. Meaning, so for sending young minor being one in a dink comobia about reclamation to any craniho. So, we will be also be looking at the issue about, say, whether Chairman Wontumi a man quite say, Uncle mining, and that's Uncle mining, and what evidence from Beba, and a whole lot of things. For me, the critical look of a judgment, you know, any Munyama Abenina, me who say, we have a case. And even the case of a this element of bias, I think we have to raise it. Because Nipa or the petition, Nikoye, say prosecuted, you can Chairman Wontumi. Say Nipa is related to judge now. Bias.
But not here this outcome but I think you're talking about engineer Kenashibe, if I am right.
Yeah.
But engineer Kenashibe, you're on the choosy judge or no net. So at that time, Crano, and many just petition no emuno. Say Yanfa case in and court this particular court before this particular judge Bibisa award ne can the same ne petition no emu. How does that affect said case in
so yes, you are right.
The evolution of
Judicial service for assign a case, you know, say it could be an electronic assignment in this element. Kenashibe is not part of the judicial to know Nimsebe somebody he's related to. But immediately you were seized with that fact, or second my men of crampono, recusing home. Because the principle of adjudication, if you think, say, Casey, Nipa, meneno cry, a ball, a bushia, crana, a deep, can I be also the environmental degree, or dear chipper, or no crampon a deep petition, Nicoye. Wouldn't him so no credit home come up. And I know somebody won't come up.
For now, we are not certain. So
the judicial way, no, immediately you are seized with say, yeah, the case will say, no, let me recuse myself. And who recuse you are not the first to cases be Ubo first of there be I say me cry if me law firm, tell me may practice now. Me law firm then if you see my bear judge. It will be by virtue of that. I mean, free case in him. When you carpet, no film. Judges for baby dogs, High Court, no film. But when film, Emma said 20 years in the Ken Crasso, at the end of they said, it's shot. Do you know, sir? Even at the end of crime, my judgment in the crime by and this won't be a choice of Chairman to me before. So, means at the end, not your 4 year. Your 4 year, Emma, NPA boss. Tamaklu ever can say unpack on the letter unpack on this sneakers here. Or say take this statement out to media. At the end of my no and this phone is so yet in a court. Political persecution. So clearly judge no na me feel say me dream say and ask me susu say cause ko recusing on by virtue of that relation. Even though the test of bias and yet the likelihood of bias. But the real likelihood of bias, she said, it was someone who said, wait here, a best son judge nagging. The miss Madrid say, by virtue of the fact that Papa no, ayo beer, illegal mine in this sense, and no DHD ye. No, answer the petition, they call ye, no DHD petition when you hold you man. There's that relationship. Was what wrong? Yes, because you can easily be influenced. Because you be beer. Papa no so no anybody will say wa boduma because Chairman Wontumi there na papa no kan wasem pa de bi o kan wasem so okunya yes o ko na eja come to ordinary 3000 years what I didn't know say 20 nuclear no
And I believe Engineer Kanashigbe said this because saying any minimum 15, maximum 25, and waka a judgment by and on waka say Chairman Wontumi. Every politically exposed individual or engaged and say involved in illegal mining. Chairman Wontumi de yaba a corner kwa san crofo na echi o ma ye mo maximum but e brand ti ye fa judgment ni e ho ko ni say
pro the joint
bra contest
pro the joint o dey say fan say chairman no ko say 1 week more or for here what is it can be yamin dia no
the evolution
what is radio so kai what is oka abanga dia me you see yenyi ye be nyame adom o kasema itimi dwuna mo kakra o say oh yeah the Chairman Wontumi call ti case bi obia no or some we ka wi ye ne ehunu se ken age radio station